Hi, everyone, and welcome today to our update on the California climate rules. We have a ton of information to cover today. So I'll try and be brief with the opening remarks, but just want to give a little bit of background on why we're here. Climate change is obviously an issue that everyone is increasingly concerned about, and we've seen multiple stakeholders, from governments to investors to individual citizens, step up their demands for entities to report on climate-related matters. Here in the US, we've been anxiously awaiting the SEC's adoption of the final climate rules, and that's dragged on a little bit longer than we all expected. And then why the SEC was working on its final comments to the rules. Behind the scenes, there were state legislatures that have pushed ahead. This fall, the state of California came out with its own climate-related reporting rules for companies doing business in California. Given the relative size of the California economy, it's the fifth largest economy by GDP in the world, and the vast number of companies operating here, these rules could have sweeping implications for companies across the country with respect to climate-related matters. Given these significant developments, we are pleased to have a panel joining us today to discuss the genesis of these new laws and the impact on companies. And we are very, very honored to have the California State Senator Scott Wiener, who was the sponsor of SB 253, also known as the Climate Corporate Data Accountability Act, which was one of the two climate reporting bills signed into law by Governor Newsom on October 7th. And we're excited to see in our audience today a lot of different folks representing different companies from various industries and regions around the country. Some are very large and based in California, and others are large but have relatively minimal nexus to the state of California. And you all have a lot of questions. Senator Wiener has been very gracious with his time with us, but he can only be here until approximately noon Pacific. And so if he needs to drop early, we thank him in advance for his time and his perspectives. And then, so I think with that, I'd like to do a brief plug. Just a lot of the information covered here today, you can review in the insight piece that we did on these rules. And then we regularly release updates on ESG and climate matters and other corporate governance and securities disclosure matters in our quarterly newsletter from the ESG Task Force. So if you don't receive that, please sign up for that. And with that, I would like to get to a quick round of introductions. So I'm Sarah Morgan. I'm the co-head of B&E's M&A and Capital Markets Practice Group. I'm based here in Houston, and my practice generally encompasses representing public companies throughout their life cycle. And a significant part of my practice over the last 3 to 4 years has involved advising on ESG, climate, and other corporate governance matters, and helping to lead our firm's efforts regarding the same. As I mentioned previously, we are delighted to have here with us California Senator Scott Wiener. Senator Wiener represents District 11 in California's Bay Area, which includes San Francisco and northern San Mateo County. Senator Wiener was originally elected to the California Senate in 2016, and he focused extensively on housing, transportation, civil rights, criminal justice reform, alleviating poverty, and promoting clean energy. Before his election to the Senate, Senator Wiener served as a member on the San Francisco Board of Supervisors, and before taking public office, he practiced law for 15 years, including nearly a decade as deputy city attorney at San Francisco's Attorney's Office. Senator Wiener received degrees from Duke University and Harvard Law School and was a Fulbright scholar. So we're happy to have another, at least former lawyer with us to help interpret things. And then also joining the panel today are two of my colleagues, Matt Dobbins and John Solorzano, who assist me in co-heading B&E's ESG task force. Matt Dobbins is a partner in B&E's environmental group based here in Houston. And he's an absolutely brilliant, multifaceted environmental partner who advises in transactional and litigation matters and really digs in deep across all sorts of environmental regulations and sustainability reporting, including reporting on climate matters and greenhouse gas emissions. So we are very lucky to have a subject matter expert here with us. And then John, my other co-lead, is based out of our Los Angeles office, and he works closely with companies and their boards on enhancing ESG practices and reporting. And he really brings a unique and valuable perspective to our ESG efforts due to his prior experience. Before he joined us at B&E, he spent the last 8 years in-house at Clorox in California, where among a number of other roles, he was assistant corporate secretary and led their ESG engagement program with shareholders. So John is often the pragmatic voice in the advice the ESG task force provides. I think we would like to turn to the panel Q&A and discussion. And the first question is for Senator Wiener. We were hoping just to get a little bit more background on SB 253, which you spearheaded along with its companion bill, SB 261, both signed by the governor on October 7th. So, I think climate change has been a critical concern for several years now. Why is California taking this step now? And we noticed that you had proposed a similar bill in 2021. So wanted to understand what's different now, and in the way that you guys were thinking about that and how you were able to shepherd SB 253 through this time.
Great. Well, thank you so much for having me. Really appreciate it. California has long been on the lead on environmental protection in general, and now climate action, back to when we were able to adopt our own tailpipe emission standards back in the 70s, which then set a national standard. We've done it through investment in clean energy. We've done it in just a number of groundbreaking laws. And we know that California, in addition to being part of our ethos to understand that we have one planet, and if we burn through the planet and destroy it, there's not another one to replace it. We also, of course, experience significant climate harms here through sea level rise and wildfires and so forth. When we started to take a look at carbon reporting and transparency, to me, it's an absolute no-brainer that large corporations should simply disclose their carbon emissions. And contrary to some of the opposition claims, it's not that hard. It's not particularly expensive. Quite a few of the largest corporations in the world are already doing it. And in fact, a number of them supported this bill. And we have a real problem with corporate greenwashing, where we literally have large oil companies marketing themselves as green. And I think the public has a right to know who's walking the walk and who's talking the talk. And so this is another example of leadership by California. This law will have national and international ramifications, and I'm really proud we were able to get it done.
Okay, thank you so much. And then just turning briefly to the substance of the law, Matt, if you can, before we get started on the more granular question, just give us a brief overview of what the law requires and what needs to be reported and when you think report, most important.
No problem, Sarah. So the basic applicability test for the law is any company with over $1 billion in revenue that does business in California. The revenue component of the test is going to be based on revenue for reporting entities prior fiscal year. And as far as it does business in California prong goes, I know you're going to get into that a little bit later with some other questions for the other panelists, but generally it's tied to certain income that's derived, whether that's property tax, property tax, sales tax, or other kind of income or charges or revenue derived from California. So again, we'll get into that a little bit later. What we don't see in the law are kind of de minimis thresholds or the equivalent of the EPA tailoring rule that applies to the federal greenhouse gas reporting requirements. I wouldn't really expect to see those kind of pop up in this. We've been moving away. The SEC climate rule doesn't contain any of those kind of thresholds otherwise, and stakeholders are continuously pressing for broader disclosures of emissions. And so anybody who's holding out hope maybe for some equivalent of the tailoring rule or establishing some de minimis thresholds, I think we need to be a little bit skeptical of that as you try and figure out the impacts to your business from this law. So what do entities have to report, and when do they have to report it? They've got to report their full scope greenhouse gas emissions. That's scope 1, 2, and 3. And by now, I'm sure everybody's heard ad nauseum. Scope 1 is your direct emissions. Scope 2 are your emissions from purchased electricity or purchased heat, steam, cooling, other energy that you purchase for use in processes at your operations. And then scope 3 emissions are your indirect upstream and downstream value chain emissions. And not very many other reporting programs to date have required the disclosure of scope 3 emissions. The closest we've come domestically is the SEC climate rule. And even there, its mandate for disclosure of scope 3 emissions is if they're material to the registrant. So when do these all kick in? Well, by 2025, CARB, the California Air Resources Board, is supposed to promulgate regulations so that reporting can start in 2026 for scope 1 and 2 emissions. And again, this will apply to the prior fiscal year. When scope 1 and 2 emission reporting requirements kick in, you only have really a requirement for limited assurance in the first few years, and then it'll kick into a reasonable assurance standard for those emissions that are going to be provided by a third-party verifier. And we're going to hear more from PwC about what those assurance procedures and the verification issues are going to involve. All of the scopes generally need to be determined in accordance with the GHG protocol. For those that aren't familiar, this is the international standard that kind of guides GHG emission accounting and reporting. And it underpins things like EU's CSRD and the SEC climate rule. So the GHG protocol is all over the place these days when it comes to underpinning voluntary reporting requirements. Now, when do scope 3 emissions kick in? That's going to be in 2027. And the limited assurance requirements are not going to be required there until 2030. The legislation's silent on whether or not we're going to ratchet up scope 3 assurance requirements at a later date, but there are other provisions in the law that allow CARB to come back and make adjustments based on developments in international frameworks and best practices. So this is what it looks like right now for the immediate horizon kind of being the next 7 years, I would say. But this law is meant to change and evolve. So we've got to pay attention to how some of these other frameworks that are connected to the law also evolve with it.
Well, that is a perfect segue to our next question for Senator Wiener. So when Governor Newsom signed SB 253 on October 7th, he applauded the bill, discussing many of the things that you just covered on critical issues of climate change and how California is leading the nation in addressing it. But he did express some concerns about the overall financial impact of the bill, as well as the feasibility of the implementation deadlines, and the potential for the reporting protocol to result in inconsistent reporting across businesses subject to the law. And he asked CARB to look into some of those issues and noted that he would work with the California legislature to address those issues. Now, understanding that it's just been a few weeks since October 7th and that you probably don't have a perfect crystal ball around actions that CARB might take, do you think it's likely that CARB will make changes to the law in light of the governor's concerns? Can you share any views around what those might be, or the kind of economic impacts that everyone's evaluating when rolling out this law?
Well, just to be crystal clear, CARB has no power whatsoever to change the law.
Well, yeah.
Period. So the CARB, only the legislature can change the law. The governor can't change the law. CARB can't change it. Only the legislature can change it. The governor made some vague comments about implementation and wanting potential quote unquote cleanup legislation, which is what he has said publicly. We don't know what he means by that. We will await to see what he proposes, and if what he proposes is reasonable and good, great, we can make a change. If what he's proposing waters down the bill or delays it beyond the already delayed implementation, then we're not going to do that. And so, the governor, I'm grateful that he signed the bill. The governor has been a long time climate champion, and we will, in good faith, take a look at anything that he proposes. And I'm always very collaborative with the administration. But unfortunately, once the governor made that statement, we then saw a feeding frenzy by the Chamber of Commerce and some of the other oil industry, the bankers, and some of the other corporate opposition to the bill, saying that they wanted to focus on quote unquote cleanup too, which for them means destroying the law, which we're not going to allow to happen. So we'll wait to see what the governor actually proposes, and we will take it from there. But it must go through the legislature, and we will only be passing something if I have anything to do with it, if it's not going to be harmful to the law's purpose.
Okay. And to that end, on any kind of clarifying items in the legislature, when we announced this and when the bills were announced themselves, we received a lot of questions about applicability to various entity structures, joint ventures. There's a number of things where there's questions about whether the law is intended to pick up GHG emissions for the whole enterprise, even if a small fraction are derived from California-related businesses. Is there any expectation to have further clarification around issues like that with companies with partially owned businesses in California, but no other nexus to the state, or how sort of any new level will play into that? Is that something you guys are considering?
Well, to be clear, the law applies to the entire enterprise if you do business in California. The law is not limited to the work you're doing in California. If you're doing business in California, then you're required to disclose for the entire enterprise. And the law covers U.S.-based corporations that are publicly held or publicly traded or privately held. That we worked intensively throughout the process with our corporate supporters, who had a lot of feedback about clarification and making sure things were clear and implementable, because I always want to make sure that any law that I author is implementable. The goal is never to confuse people or make it hard or ambiguous to comply, which is why, for example, we allowed for the use of formulas and estimates for Scope 3. That was a big move that we made in consultation with folks in the corporate community who were positive about the bill and supportive. We made changes about if you're already complying with the same data in another jurisdiction, we don't need you to recreate the wheel. You can literally just like staple the report from the other jurisdiction if it covers everything that this law covers. Those are just two examples. We made a series of changes based on very detailed corporate feedback. Of course, if there's anything that was passed in the law where something is really confusing to people, some of it, there are some things that CARB can handle in implementing regulations if it doesn't change the law itself. But we're always happy to take a look at anything that folks are confused about.
Okay, thank you. And then I think related to that, there has been a lot of questions around the phrase "does business in California." And we noted when we reviewed the legislative history that that language mirrors the language in the California tax code that categorizes an entity as doing business in California if it has 610,000 for sales in the state, 61,000 in property, or 61,000 in payroll. Is that expected to be the standard for doing business in California for these laws too, or is that an area where you expect there to be further guidance developed?
I think I would think that if it's the same language, I would think it would be the same. But I'm sure there are lawyers on this Zoom who would probably have opinions about that.
Okay, and then related to that, and sort of related to the CARB role in this, the law specifies that CARB will develop and adopt prior to implementation dates the details of the regulations related to enforcement mechanisms, Scope 3 reasonable assurance requirements. Do you guys have any current expectation of when CARB might issue the guidance on applicability and interpretation of the law on those areas, or any of the other areas that we discussed previously where they may weigh in with some guidance?
Yeah, I don't have, I apologize, I don't have the bill right in front of me. I believe they have 1 year, if I recall correctly, to January 1st, 2026, but someone can double check me if I'm wrong about that, to issue their initial regulations. And then the first disclosures of scope 1 and 2 would be in, I believe 1 year to January 1st, 2025. And then 6 months later, for I think it's in 2026 is when the scope 1 and 2 disclosures occur. In 2027 is when scope 3 emissions are disclosed. I should have refreshed my memory on the timetable, so sorry if I screwed any of that up. And then in 2030 is when scope 3 goes up to the higher assurance level. And then 2033 is when CARB is authorized to do a review of the standards and to determine whether the GHG protocol still is the best standard, and whether there should be a different standard.
Yeah, no, thank you so much. And I agree, that's clearly laid out in the law. I think people are just anxiously awaiting a lot of that guidance and wondered if it would come in the nearer term, or if it was likely to be the full year there. But and then I guess with that, John, I'd like to turn briefly to you just to get your perspective here. Having heard all that, heard a little bit about implementation and when and how this is expected to roll out. So you spent many years in-house in roles similar to the people in the audience here today, at Clorox and elsewhere. How do you expect the new California climate laws to impact public corporate issuers, who would also need to report against the SEC rules whenever those are final, but also other reporting regimes in other jurisdictions? What are people doing? How are people thinking about this to prepare for this?
Yeah, so I think what California is doing here is interesting, and it's a bit of a paradigm shift over how historically public companies at least think about disclosure. Typically, we apply a materiality lens, and would sort of disclose decision useful information to our investors. I think the way that SB 253 is laid out, and would love to get the senator's perspective on this about misconstruing this, is really there's not that same level of kind of inherent materiality analysis. It's you just need to disclose it. And I think that in some ways is very clarifying. It's pretty simple. You don't have to do that analysis. You just have to disclose it. And I think there's probably some helpful allowances in using estimated data, which the senator referred to, as opposed to really having to get super granular into your actual scope 3 emissions, for instance, which for many companies, including the companies that I previously worked at, that's upwards of 90% of your greenhouse gas emissions profile. And so being able to use estimated data may make that a simpler exercise. What I could see as being a challenge is if you're disclosing this information, publicly to California, yet you're also disclosing to the SEC under a certain materiality threshold, or you're also reporting to the CSRD for the EU if you have an EU nexus, or any other jurisdictional place, or if you're voluntarily reporting under the TCFD, you could start seeing some discrepancies between what you're reporting or required to report to California versus what you're reporting sort of on a voluntary basis or under kind of a different materiality threshold. I think, to the point that the senator made earlier, companies need to be very mindful about that, and be, thoughtful about, you might be saying one thing in your sustainability report about how you're decarbonizing, and then you actually have all of this information out there about your GHG profile that is publicly available. I think this is intended to mitigate risks of greenwashing. So you can't say one thing and then you sort of have to prove it on a publicly available registry. So I think that is going to be something that in-house practitioners are going to be very thoughtful about, saying one thing in one place and saying another thing elsewhere. I would also love to get the senator's perspective on this as well. As somebody who worked at a consumer-facing company for many years, I know that sort of the extra legal levers can be very impactful for companies, and being cognizant that if you're putting something out there publicly, that's something that stakeholders are going to be monitoring, and it could have impacts on your business. It's not just sort of the regulatory requirements to do it or the legal exposure associated with that. Frankly, I don't interpret these rules as having a ton of sort of fees or fines associated with the disclosure itself, but I could see some of the reputational issues being very impactful for at least some subset of companies and motivate them to continue enhancing their profile as a result of the public disclosure. So I see that as kind of a key lever here, but also it could expose companies to some risk if they're not being very thoughtful about the consistency across their reporting frameworks.
No, I mean, that's a great point, John, and sort of getting back to something that Senator Wiener had mentioned earlier. I think, you said you were willing to think about changes or, perhaps cooperation on the legislation to the extent that it doesn't water it down, doesn't sort of water down the core mission. I guess, Senator Wiener, do you think it's possible that once we have, more clarity around, for example, the SEC rules, that there may be cooperation among the various governmental organizations to make the reporting landscape a little bit more cohesive, sort of using some of the same guidelines so people aren't reporting under multiple different standards?
Well, if what I'm seeing with the SEC rulemaking process holds and continues, then that would quickly become a race to the bottom, because the SEC, it's not looking so great. A lot of the corporations that are fighting the SEC to the death on that rule, and it's being pared back, and it might potentially jettison Scope 3 entirely, or have a very, very limited version of Scope 3. And so we definitely are not looking to the SEC as being likely to set what we think is a good standard. So we would love for the SEC just to be consistent with what California is doing. And of course, in an ideal world, Congress would just pass a strong disclosure law and we'd have one standard for the whole country. We know that's not going to happen, or it's very unlikely to happen in the near future. And in addition, whatever the SEC adopts, if the insurrectionists come back into power, and that they, Trump or whoever will just revoke it. And so I think it's really important for California to set a strong standard. And again, we really worked hard to make clear that we don't want you to have to report what you're already reporting in another jurisdiction. And so if you're reporting everything that we require in another jurisdiction, all you have to do is submit that report. If it's 80% of what we require, you submit the report, and then the other 20%.
Senator Wiener, you touched on this earlier, and also in looking at the legislative history of the bill, it does look like the legislature discussed and considered some of the challenges related to Scope 3 reporting, and that obtaining data in the supply chain is challenging. And that the legislature did specifically provide allowances for estimated industry averages, proxy, and other data to meet the Scope 3 emissions reporting requirement, versus the concrete and verified emissions data through the company's value chain. Can you tell us just maybe a little bit more about how you guys thought about that and balance that versus, balance considerations there, versus where companies kind of are now in terms of their preparedness to report?
Yeah, that wasn't the legislature. That was me. As the author of the bill, I made that amendment in response to feedback that we received from folks in the corporate sector, that chasing down micro suppliers around the globe was going to be hard to impossible. And so we took that feedback seriously. I always, like I said, I want any bill that I author, I want it to be implementable. And we're not trying to make life hard for people. And so we worked on that amendment. We also delayed implementation. And in addition, even after Scope 3 goes into effect for the first few years, there is no penalty for the content of your Scope 3 disclosure. If you don't file it, if you blow it off, you can be penalized. But for the first few years, if you submit audited scope 3 and there ends up that there was a mistake in it or something inaccurate, that you just correct it and you don't get a fine. The fines don't kick in until I think it's 2030. And so we really, it's a very gradual phase in of this. And we did that because we know that scope 3 is complicated. We want to give plenty of time for companies to figure it out. The methodology is there. We didn't create anything new with this law. This is all existing methodology that there are corporations, large ones, that are already doing it. But we know that it's going to be a change for a significant number of corporations who are doing business in California. And so that's why we did that gradual on-ramp. And I think it's a quite reasonable on-ramp for corporations.
This sort of gets back to one of the questions that we had around entire enterprise earlier. So entities, again, as we discussed, had a variety of corporate structures, and this is designed to pick up the entire enterprise, not just the part in California. But frequently, there are companies have joint ventures, or they have enterprises where there's other participants that they don't completely control. They aren't going to be able to completely control the flow of information. Senator Weiner, is it intended to pick up those as well, and they just do their best at calculating that based on the information that they have, or is there something that would exclude it, where it's an entity where they don't have control over being able to collect that information?
I'm sorry, can you just repeat the first part? I was looking at the comments, and so I missed the first part, but you said. I apologize.
Yeah, I'd say a good half of the questions that we've seen on this so far are around trying to clarify what entire enterprise means, which we know it's the entire operating business, not just the pieces that touch California. But then there's been a lot of specific questions around joint ventures, minority interest in joint ventures, 50-50 joint ventures, other affiliated companies where the company doesn't necessarily completely control the operations and doesn't control the flow of information. So it's much harder for them to be able to accurately obtain emissions data. And so I think there's a lot of questions around that. What are the reporting obligations under this bill with respect to those entities?
I mean, with subsidiaries, I saw a question about that. I believe that is included. And one of the sort of philosophies underlying this bill is we don't want companies to be, if companies should not be able to avoid disclosure by contracting out their carbon emissions. That's why scope 3 is so important. As John was saying, for a lot of these companies, it's 90+% of their emissions. And so if you don't include scope 3, I would have abandoned the bill without scope 3, because that's a large majority, and it would just allow them to contract out their emissions and hide it. And so same with subsidiaries. Joint ventures, I'd have to go back and take a look. I can't really answer that definitively now. It might depend on the type of joint venture and what the structure is, but I can't definitively comment on that at the moment. And just to be clear, even though I am a lawyer, I don't give legal advice anymore. I used to, but I don't anymore. So no one should rely on anything I say to make decisions. You are lawyers, and we need to make sure people consult with their lawyers.
Okay, thank you. And then, sort of piggybacking on that a little bit and trying to drive corporate and other behavior, and also, contracting, everything around that. John, as you mentioned, you worked at a consumer-facing company for many years where some of the non-legal aspects could really drive corporate behavior shifts. How much of this law do you think will drive corporate behavior shifts as a result of reputational issues if all of the carbon emissions are on public display as anticipated here?
So I think it could motivate corporate behavior. I think as of now, I don't know that most consumers will know what this data means, but I think that there will probably be a learning curve, and it will become probably better understood over time. I think at least for now, one of the key considerations is making sure that the disclosure out there is consistent across your various reporting regimes, which I alluded to earlier. I do see some risk, though, where I can see the plaintiffs bar starting to poke their head in and just trying to connect the dots and make sure that folks are saying what, they're walking the talk, and you say you're doing one thing here and you're not doing the other thing when I can actually see the publicly reported data. And that could be a motivator for some companies. I do think that some of the more sophisticated, at least public consumer-facing companies will probably be fairly attuned to what their data is saying because they don't want to look bad. So that could be a motivator. I don't know that that's going to be a motivator for every industry, but I could certainly envision some industries where it could be a significant motivator. One of the things that I didn't mention, and it's been kind of alluded to throughout this discussion, is one of the challenges with all of this reporting is it's one thing for public companies that are, basically have reporting teams that do a lot of this work already. I could see this being at least challenging in theory, at least initially, for some of the public or some of the private companies that have never really had to do this type of disclosure in the past, and maybe trying to figure out like setting up teams to do this, and maybe as the reality of this shakes out and the ability to rely on estimates may simplify some things. I would just say it kind of my first initial pass that gives me some concern is just the burden on companies to do this. But I know that the senator has already sort of alluded to the fact that the way that the bill is constructed, that doesn't appear to be the intent. The intent appears to be to simplify this and make this not as onerous as maybe it appears on paper. But that's something that I would just be very cognizant of as a practitioner. And I know that a lot of the folks listening just want to make sure they understand what the implications are on their organization, because everything has inherent trade-offs. If you're focused on reporting, that means you're not focused on executing for the business, and that can be a challenge. And that's something that I know that a lot of folks are going to want to understand what that means for their business. So that's my only, my primary word of caution. But maybe that will ultimately become less concerning once the reality of this sort of shakes out, and you're able to rely more on estimated data and third-party assurances to ensure that data is accurate.
Senator Wiener, I guess, were there any follow-up thoughts on that, or as you guys thought about the, including the private companies in the ambit, and just the way that you guys approached that in terms of readiness?
Well, I mean, this applies to corporations with gross annual revenue of $1 billion or more. So these are not, micro businesses. We thought it was really important to include privately held corporations. There are some really, really large privately held corporations. We don't think that this is something that's going to be distracting to companies. So many corporations are already doing it and already doing scope 3. There are so many resources available. It's a gradual implementation. As I said, we even delayed the fines by a few years, because it's not intended to be a gotcha. And so we think it's reasonable, which is why Microsoft and Salesforce and Google and Apple and Amalgamated Bank and Patagonia and Dignity Health and a whole laundry list of corporations didn't just say we're going to do this. They literally endorsed the bill. So we think it's a reasonable, well-crafted bill. I saw a comment, isn't this just going to push companies to Texas? No, this isn't about where you're headquartered. If you're headquartered in Texas and you want to do business in the 4th largest economy in the world, California, if making these disclosures means you're not going to do business in the 4th largest economy in the world, that's your choice. I would be seriously surprised if any corporation made that decision.
I do think there was another interesting question from the audience on whether we've talked a little bit about how if you're already reporting for other jurisdictions, you can simply tack on this report. Are there any jurisdictions now that you consider comparable, EU or otherwise, or headed in that direction?
Well, this is the first in the U.S., so nothing in the US,
Yeah.
you know, in existence. With the EU, that's still also in process, so I can't really comment on that yet. I think there'll probably be a lot of similarities. Obviously, I would love for them to be exactly the same. The EU, for reasons no one understands, decided instead of going with the GHG protocols to create its own bespoke standard. We don't know why they did that, but they did that, and you know, and we don't really have control over that. We think the GHG protocol is sort of the gold standard for this reporting, which is why we went with it and why we gave CARB, starting in 2033, the ability to reevaluate. And I think in 2033, the landscape will be much clearer, and we'll have the ability to do even more work to try to dovetail some of these regimes. And I apologize, I do need to jump off. So I'm sorry about that.
No, thank you so much for everything. And I do think that we've gotten a lot of valuable information. So we really appreciate your participation today.
And we do, as with any law I author, if there are, you know, once everyone goes through their consultations and figures things out, if there are examples of like this provision in your law is really unclear, there's something that needs to be clarified, or we think there's a mistake, or, you know, we definitely I always welcome that. Like I said, I don't want to water down the bill, but I want any law I author to be, you know, as well crafted as possible. So we welcome that kind of feedback for sure.
I have a feeling there are probably going to be a number of people taking you up on that. But thank you so much for joining us.
No, thank you. Really appreciate it. Thank you. Have a wonderful day, everyone.
Great, thank you.
Bye-bye.
And then with the remainder of our time, I'm going to continue on with a few other questions for our panelists. So some follow-up questions for John. Do we think that this is going to lead to new incremental liabilities for companies?
I certainly think it could. You know, as I mentioned earlier, you know, I wouldn't be that concerned with the administrative penalties associated with, you know, failure to comply or making a misstatement. It sounds like there will be some safe harbors for some of the disclosures, but I do think that there will be enhanced scrutiny. I mean, we are seeing a significant amount of litigation around greenwashing claims, and I think that the more sort of elevated disclosure that's out there that's theoretically provable or objective, and that's inconsistent with some of the things that you're saying that's maybe a little bit softer or aspirational, that could create some, I would say, incremental liability for companies. Then you obviously have the reputational issues that I think companies will be looking hard at, because, you know, while it's hard to maybe directly link a reputational issue with the bottom line, it's clearly there, and you can you know, decrease the sort of the aura of a company if, you know, you are seen as a bad actor because you're putting out more greenhouse gas emissions than maybe your customer base would expect you to be. So I think that there could be some theoretical incremental risks associated with this. And that's not to say anything about the SEC or other regulatory regimes that you would be required to report to. And I think that there could be some concerns around inconsistencies there. You know, the SEC has historically prioritized ESG disclosures in the last couple of years as a focus area for them. So I could see that being an area that they focus in on. If you're now disclosing this publicly in California, why are you saying something differently in your SEC disclosures? So all of those things I think could create some incremental risk, and it's something where I would advise companies to be well advised as they're going through this.
Yeah, no, I think it'll be really interesting to see what the SEC final rule looks like in light of, you know, this being adopted earlier, whether they ultimately are going to be watered down, as Senator Wiener was concerned about, or if they, you know, toe the line something more similar to what California has done now that that's already out there. So that remains to be seen. Matt, I wanted to turn back to something that we were talking about a little bit earlier. SB 253 specifically calls out reporting in accordance with the greenhouse gas protocol, which I understand is currently under revision. How would you expect changes to to the greenhouse gas protocol to impact compliance with these laws? And they're, what do we think is going to happen there?
Sure. So the GHG protocol is going through one of its standard revision processes right now with a target to release draft rules for consideration in 2024 and to finalize them by 2025. They're reviewing every standard. So the standard that guides determination of scope 1 emissions, scope 2, and scope 3. And when we look at the comments that have come up so far in response to survey questions that have gone out, we're seeing some interesting trends kind of develop. First of all, on scope 2 emissions, there's a big question of whether or not we're going to continue to allow the use of market instruments as a means to lower your scope 2 emissions. And what do I mean by that? Your purchasing of renewable energy certificates. So if those go out the door, your scope 2 emissions potentially go way up. We could also see restrictions on the use of RECs for kind of lowering scope 2 emissions. There's been some discussion of the hour by hour matching in terms of renewable generation to power consumed. That's similar to how we've seen the EU start kind of evolving some of their approaches to determining the carbon intensity of things like hydrogen. And I do think there's some risk of the GHG protocol actually heading in a more European style direction. One, just because of where most of the people that are writing this sit. And two, when you look at where the bulk of the comments in response to the surveys are coming from, it's from people in the EU. So those trends are really going to dominate this. They're also talking about addressing double counting concerns in these revisions to the GHG protocol. And I see we've gotten a number of questions in the chat on double counting. And that's really where the legislation is kicking everything to the GHG protocol to handle some of these more nuanced or granular issues. And that's not unusual. The SEC climate proposal did the same thing. But double counting is inherent in some ways because someone's scope 3 emissions are someone else's scope 1 or 2 emissions. So we are going to see one entity reporting a set of emissions and another entity potentially reporting the exact same thing. And the double counting is not really so much of it. The reason why people who are pro scope 3 disclosure don't view that as a concern is scope 3 emissions, right, are your metric for determining vulnerability to transition risks. So double counting, in a way, that big number of scope 3 is supposed to indicate if we move to a more stringent regulation of carbon, low carbon economy, this company potentially more affected, more impacted. So the double counting piece really isn't as persuasive when you're addressing scope 3 emissions as when you're trying to adjust scope 1 and 2. But the real big kicker out of all these GHG protocol emissions that I want everybody to watch out for is there is a lot of chatter in terms of adjusting how to account for CO2 removals, the use of biogenic sources in power generation and fuel consumption, and ultimately what you determine the GHG emissions from the use of those products or those activities to be. We're talking about the pillars a lot of companies have built their decarbonization strategies on. And so you're going to see how you grade yourself against your progress on those strategies changing. At the same time, we're going to have regulatory requirements come in. And I would say the way the legislation is written, that arguably you have to follow whatever version of the GHG protocol is in effect at the time of your reporting year. There's nothing in the legislation that kind of ties it to the existing standard or suggests that it doesn't, immediately pick up updates as they're finalized.
And that was what I was going to ask you too. And you don't think that there's any flexibility there for CARB to layer in its own guidance? It's at least as written, relying entirely on the GHG protocol.
The CARB will have the ability to incorporate those alternative standards the senator mentioned, but those really are not going to come into play right until CARB does some more of its studies that don't happen until next decade. So I really do think all the action is going to be centered on the GHG protocol and how that flows. And the timing is going to be really tight for understanding the implications of the revised protocol to hit the 2026 reporting.
Okay, thank you. And do you think that this then subsequently impacts the way people track or count or calculate their just as a follow-on their emissions reductions and report that too? Does it have a any further impact or different impact there than from what they were already doing?
I think it certainly can. We're just going to have to wait and see what the GHG protocol says. Right now, the protocol is kind of silent on how to address some of the more complicated issues. So, we've worked with a number of clients to try to help them figure out how to credibly claim an emissions reduction and assign it to a scope bucket. And, while in terms of voluntary reporting, you've got some flexibility to deviate from the protocol, you don't have to strictly follow it. For everything we've heard from the senator today and the way the legislation is written, you don't have that flexibility under this requirement that will be imposed under the legislation.
Okay, no, that's very helpful. And then I think, as we think about this generally, I'd like to hear each of your perspectives on what we think that the next steps are for the participants on the phone and otherwise now that SB 253 is law. Between John, Matt, and myself, we've done a ton of work helping clients get ready for climate reporting, whether voluntary or sort of expected from SEC rules or otherwise. So I'm curious in your view of what's next, and then more specifically whether you think we're going to see even more internal controls around this type of reporting, or even more layers of governance around this type of reporting.
Yeah, so what I think is potentially interesting is, what does the California law or laws, what does that do for the impending SEC rules? Does that give some more sort of political cover to the SEC to be a little bit more aggressive with something that you saw a couple of weeks ago, about 25 Democratic Congress people sending a letter to Chairman Gensler basically saying, well, now California is doing this, so let's make sure that scope 3 is within the final SEC rules. So it's possible that this could potentially push things a little bit more aggressively, but it's also possible that it couldn't. And that's just conjecture at this point, and more sort of political tea leaf reading. I would also be curious how this is going to potentially get caught up in the court systems. There will probably be some challenges to this, and there will certainly be challenges to the SEC rule whenever that comes down. And so that could impact what the final rules look like. It could impact the timing of it. And so I would just be curious to see how that all shakes out. And while that's happening, every company should be well advised to be gearing up for the rules as written, and be preparing for that, and talking to your firms, talking to your auditors about what you need to do to start getting ready for the rules as written.
And then turning back to Matt, what are your thoughts from your perspective on what's next?
So I fully appreciate looking at the comments that a lot of people in the audience, their heads are exploding. To be clear, right, we've got 3 different climate laws California has passed that have potentially far-reaching extraterritorial, impacts, right? And so the one we focused on mostly today specifically relates to the emissions disclosure. That's the 253 bill. I saw one question also as far as 261, that's the TCFD related disclosures. That also has to be made to CARB, just so we're clear. So 2 of the laws are about disclosing climate related information to CARB, whether it's emissions or emissions plus. One of the laws that Valerie mentioned also touches on the offsets. That's something you disclose on your own website. In terms of what I think is coming, is that we're going to have an increasingly more difficult time approaching this and trying to understand these laws from our classic financial reporting framework, because it ties back to what John said. A lot of these laws are moving beyond the financial materiality kind of impact framework. We're moving beyond concerns about investors to concerns about stakeholders more broadly. And so that's part of why we see environmental agencies now assuming a disclosure role. But it's really more about just, again, letting the public and other stakeholders gauge transition risk and other climate related risks. So the sad thing is that the pendulum really seems to be, that just means we got to share all the data. I think there is risk, to John's point, of information overload and a learning curve that's going to have to be dealt with for us to really get some value out of these. And so my only kind of advice on how to really parse through this is, identify your low-hanging fruit in your emissions inventory first. So that hopefully is already your scope 1 and 2 emissions. And so if you haven't started on scope 3, EPA, to the senator's point, does have a list of emission factors that can be used for the various buckets on scope 3 emissions. So there is help out there. But I do think it's really important that you start identifying the more difficult aspects of this first, and so that we can figure out, all right, what's your ultimate strategy? Are you going to try and engage with CARB in the rulemaking? Are you going to try and engage with policymakers to get some legislative relief? Potentially that might be more difficult. But overall, everyone needs to be aware of, we're going to have to start looking at the most stringent regime out there and doing our best to follow that within reason, because all of the others are slowly catching up to the most stringent one out there. And whether that's the CSRD or these new California laws, I don't quite know yet, but I do think those are probably the prime examples of the more stringent kind of frameworks we'll be operating under.
No, I mean, I think that's really interesting, and particularly the point of it's so much data. Do you think that people will continue to take the approach that they have, given that there's already all these other reporting regimes that many people, report under several of them and have those, on their website or as an appendix to their reports, but they have, they have this general, more specific highlights, what they perceive to be sort of the material elements of those reports in their sustainability or corporate responsibility report. Do you think we'll still see that, or people will think that there's some risk, now that this is mandated, that that there's not full coverage of that in their sustainability report?
I think it's going to come down to your individual investor stakeholder mix, right? If you have investors that are used to seeing your ESG metrics or your climate metrics specifically presented in a certain format, that's what they're used to seeing and how they factor it into their own decision making, right? So you could, as a reporting entity, still face pressure to put out your voluntary report if you've got a few large shareholders that say, this is how I'm used to getting it. I just plug these numbers into a model, and I don't want to have to figure out how to plug the California numbers into my model. So we want you to still keep doing this. So I think there's going to be some continued pressure in the voluntary reporting space. The question is going to be, how robust will it be in light of these legal kind of drivers that are now coming out in terms of emission disclosures and other ESG metrics?
No, that's super helpful. And then, there was an interesting question in the chat here about the role of technology solutions in data collection and emissions inventory and reporting. And I suspect that we've all had, some interplay with that thus far. Do you have a view on whether what the role of technology solutions will be going forward? Will this drive more of that? What are you already seeing out there as you guys work on helping people with these reports and assurance?
Not to bring this whole other super relevant concept to the discussion, but AI, I think, could start disrupting some of this, because there's just going to be so much data out there, and I think that it's going to get much more sophisticated to kind of crawl that and be able to provide maybe slightly more accurate information, but with that power comes risks. And so I think companies also need to be very mindful about leveraging those tools in a way that actually produces results that are meaningful for the reporting requirements that they have or for their stakeholders.
No, I completely agree. And you are correct that is the topic of a completely separate, more than an hour and a half panel seminar, the uses of AI here and the risks associated with it. I guess, is there any closing thoughts that each of you would like to share with the audience, or thoughts or responses to anything that you heard from Senator Wiener or your co-panelists, or any of the questions in the chat that we haven't addressed that you guys have thoughts on here?
The one thing I would throw out there is I know that Senator Wiener mentioned, the intent of this law is to not be super burdensome, like the ability to use scope 3 sort of estimated data. I think time will tell whether or not that is true. And so, I do think that this will still feel pretty burdensome to a lot of the people who are listening here who maybe don't have the internal functions to address this stuff. And so it's going to feel potentially like a big slog to get through this, especially initially. You know that you have support and, folks are here to help as you kind of embark on that journey. But I don't know that it's going to be as simple as just plugging in the type of company you are and then it spits out your scope 3 emissions and you just report it. I don't think it's going to be that simple. So I think that there's going to be a fair amount of internal kind of churn within the organization. You're also going to want to make sure that the folks within the organization are getting the right eyeballs on this. So you're going to want to also stand up internal reporting controls for this type of data. It's now going to be publicly reported. Folks within your C-suite need to understand it. Folks within your boardroom may need to understand it. So I think that there's going to be a good amount of governance associated with this and making sure that you're getting the right eyeballs on it. And it's not just somebody deep in your CSR organization that's reporting this stuff, because this will be publicly available and it's going to be a different level of scrutiny than maybe some of the sustainability reporting has done in the past.
Yeah, I think that's a good point. And, I go back to they did try and take that to account with the bill and tried to, provide allowances for estimated industry averages and proxy and other data, particularly for scope 3. I mean, do you perceive then if someone who's new at this and doesn't have access to that information and relies on that, do you think there's a risk to doing that? Extensively versus actually, getting the infrastructure to and the contractual arrangements to assess, to really assess your own emissions without having to rely too heavily on those provisions?
Yeah, I mean, I think that it's probably helpful that there are these safe harbors around disclosures, maybe good faith, and there's no penalties associated with inaccurate disclosures, at least I think it's until 2030. But I do still think it's going to be a little bit more organizational burden than maybe we are anticipating. And so we just need to be very thoughtful about what it looks like on the inside to have to do this stuff. And that's going to require collecting information from your supply chain, potentially. Even if you can use estimated data, you still need to understand what your supply chain is in order to input that into the models to kick out the estimated data. Not every company has really thought through that, and the systems that they have internally aren't necessarily set up for that type of data collection. So it's going to require a good amount of work. And so I just want to be thoughtful of the folks who are listening. This is going to potentially be somewhat burdensome on them and may have to build out new functions that they don't necessarily have in place right now.
That's a terrific point. And much like the SEC rule process, we already have a number of clients who are very interested in asking for clarification and guidance and, lobbying for certain positions on that guidance with respect to the rules. So that's an excellent point. And then in terms of, I think we've had a few questions in the chat about, potential litigation challenges to this. And we know that, that there's a great expectation when the SEC issues its final rule pretty much in any form that there's likely to be significant litigation challenges to that. John, any thoughts on how that might be approached here, or how that may impact the process as people move forward to set up to comply with this?
Yeah, I mean, I certainly think that there will be challenges. I don't know what they're going to look like. I can sort of imagine several types of challenges, probably premised around the Commerce Clause and the Dormant Commerce Clause and things like, forced speech that, I'm not a constitutional lawyer, so I can't really get into whether those have any merit or not, but I could see those types of things being proposed. And especially if you see the SEC come down with a rule that there may be some preemption claims there, that we should only really have one standard. What is interesting is the SEC is going to only apply to public companies, and this applies to a much broader swath of companies. And so I'm not sure how that's all going to shake out, given that these are kind of addressing slightly different audiences. the anticipated number that was in the legislative history was in the 5,000 to 7,000 companies range was the estimates of folks who are going to have to report against SB 253 and 261. More would potentially get caught up in 261 because there's a lower revenue threshold of $500 million. So I think that it'll be an interesting thing to see how that plays out, and would love to get perspective from litigators as this starts unfolding. I did want to address one question that I saw in the chat come up as well regarding the perspective from institutional investors, and I agree it would be great to get their perspectives directly on whether they would find this to be decision useful information. My supposition is, they've been very focused on the TCFD for a number of years, and obviously the SEC rules are replicating the TCFD in a number of ways, and that's viewed as kind of the financial materiality that's important to shareholders. I think to the point that Senator Wiener was making earlier, this is not just about shareholders. This is about broader stakeholder groups and the planet generally, and the state of California in particular. So I think that your institutional investors, I don't know if they would find this additional information to be particularly helpful. It might just be noise to them, and they are getting used to seeing information in sort of the TCFD format that talks about risks and governance and targets and metrics and things of that nature. But I would be curious if they're starting to see enough data in the aggregate that they can start to flesh out some trends that might impact their investment decisions.
No, thank you. Very helpful. And then I think in terms of key takeaways here, I think we got a lot of color from the senator on sort of the intent of this, that it was intended to, to broadly pick up anyone doing business, and that likely the threshold for that is that tax code threshold, and that was intended to pick up emissions across the entire enterprise, notwithstanding some potential follow-on questions that I'm sure we'll all be submitting on joint ventures and other structures. I guess, do you think that will have an immediate impact on the way people think about, and we've talked about this a little bit, their other corporate goals, again, getting back to the reputational issues now that carbon emissions are on public display. There's sort of the broad nature of this rule. How do we think that that's going to impact public company behavior? And maybe, John, you're probably best suited to take that.
Yeah, I don't think that these are fully inconsistent with one another, but I certainly think that at a minimum, this is going to serve as a distraction, maybe to use a poor word. It's going to require mind share that is probably not something that a lot of companies who are trying to progress towards their net zero ambitions or whatever their ambitions may be, having to disclose this information and collect this information on a somewhat granular basis might feel a little burdensome. And so that may feel like they're kind of distracting. But I think to the point that I think Senator Wiener would make, these are complementary concepts in a way. Like, you're making this goal, and now there's data that's publicly backing it up. And so I think that those two things could be working hand in glove if done correctly and is not too burdensome on companies. And the information that you actually get out of this is decision useful, or at least accurate, which I would hope at a minimum it is. And hopefully with the assurance requirements, that would be the case, that you are going to be seeing some accuracy. But I also do fear that this could, be a boon for the plaintiffs bar, and that's going to serve as a distraction for a lot of companies as well. So those are the kind of the competing considerations that I would be thinking about.
I was thinking more about the inverse, rather, if you're a company that didn't previously report this sort of information, and now all your information is out there, which I think maybe some of the impetus behind this, does that make you think more about implementing some of these emissions reduction strategies, if not setting specific targets?
Yeah, sorry, and I certainly think it could, but I can't speak for kind of the intent for every corporate strategy. I think every company should be following whatever the strategy makes sense for them, and I wouldn't let the tail wag the dog. If this is not aligned with what your business strategy is, don't change your strategy as a result of this. If it is the kind of impetus that you need, the nudge to make that commitment that's already aligned with your strategy, I think some companies are going to do that. So I think, you know, it's hard to say. It may, on the margins, I think, motivate some companies who otherwise wouldn't, but I don't know that it's going to lead to a sea change of commitments.
Okay, thank you very much. Any other parting thoughts from any of our panelists today? And otherwise, I think we've done our best to address the questions that have popped up in the webinar chat. But if you have any follow-up questions, feel free to reach out to any of the contacts here from B&E. And also, as the senator mentioned, you know, they have a process for, you know, for submitting clarifying questions to them as well, to try and make the law implementable from the company's perspective. And we appreciate your time with us today, and thank you for joining us.